A very good day. Today I will be discussing the Coronation tax case. Let me give you some background. Economic and legal context of the case. In the mid-1990s, as South Africa re-entered the global community, exchange control regulations were gradually relaxed, enabling South African companies to establish foreign subsidiaries and participate more freely in global markets. In 2001, a significant tax system change occurred, shifting from a source-based taxation model to a residence-based model. Under this new approach, South African tax residents were taxed on their global income. To mitigate potential tax avoidance strategies, Section 9 Cap D of the Income Tax Act was introduced, specifically targeting income earned by controlled foreign companies, CFCs, and laying out conditions under which foreign business income tax might be exempt. Now let's look at Coronation's corporate structure and operations. Coronation Investment Management SA Pty Ltd, CIMSA, is a subsidiary of the Coronation Group, a prominent investment management firm. To access international markets, CIMSA established Coronation Global Fund Managers in Ireland, which is now called CGFM in Dublin in 1997. This entity was created to manage Irish-domiciled collective investment funds, as South African entities were prohibited from directly managing these funds under Irish law. CGFM's business model mirrored that of CIMSA's domestic operations in South Africa. CIMSA's fund management entity outsourced investment trading to a licensed specialist, Coronation Asset Management Pty Ltd. Similarly, CGFM outsourced its investment management trading to Coronation's other subsidiaries, Coronation International Limited in the UK and CAM in South Africa. Now let's look at the tax dispute origins. For the 2012 tax year, SARS assessed CIMSA's tax liability, imputing CGFM's income to CIMSA, and contending that CGFM did not qualify as a foreign business establishment, FBE, because core business functions were outsourced. SARS asserted that CGFM lacked the necessary economic substance in Ireland. The tax court ruled in favor of CIMSA, finding that CGFM had sufficient on-site operation staff and facilities in Ireland, and thus met the FBE criteria. However, SARS appealed, and the Supreme Court of Appeal sided with SARS, emphasizing that outsourcing core activities undermined CGFM's claim to FBE status. Now, what were the key issues? Let's look at the definition of business and primary operations. The central issue was whether CGFM's outsourcing of investment management invalidated the status as an FBE under Section 9 Cap D of the Income Tax Act. Let's look at the FBE exemption requirements. The case then explored whether CGFM's activities in Ireland were substantial and met the requirements to claim tax exemption. What were the findings in the case? So the tax court ruling was as follows. The tax court ruled that CGFM was a legitimate FBE, fulfilling the necessary criteria of having a fixed place of business with adequate staffing and infrastructure. It set aside SARS's additional assessment and penalties. Now let's look at the Supreme Court of Appeal ruling. The appeal overturned the tax court's decision, holding that CGFM's outsourcing arrangements disqualified it from being a recognized FBE. Therefore, CGFM's income was taxable in South Africa. Then we move on to the Constitutional Court ruling. CIMSA then appealed to the Constitutional Court, arguing that the Supreme Court of Appeal's decision imposed an impractical standard on international business operations. What was the conclusion? The Constitutional Court dismissed Simpson's appeal, affirming the Supreme Court of Appeal's decision. The court held that the FBE's exemption requires that primary business operations not be outsourced and must be conducted in the claimed foreign jurisdiction. SARS ultimately prevailed and CGFM's income was deemed taxable in South Africa. The court emphasized that legitimate outsourcing practices should not undermine tax laws designed to prevent avoidance. Thank you very much.